Hello everyone, my name is Dhruv Tomar. I am an intern at LEXIS and Company. Now, today in this video, we are going to discuss that if one of our clients has done XYZ, any of the crime, and he is hiring a lawyer, as we all have to act like a lawyer. So, if he is hiring a lawyer and he expects us for bail, so what is bail? What is the historical development of bail? What are the types of bail which are available in our Indian judiciary system or our Indian legal system? So, starting with the video, first we'll discuss what actually the bail is. What does this word bail means? So, bail is the conditional release of a person accused of a crime for an amount pledged for the appearance of the accused when the same is due in the court. Now the person paying the money acts as a surety. Getting bail is one of the rights of the accused in a civil case, while it is discretion of bail granting authority in a criminal case. So in a civil case, one can either pay the fines and get his bail, or he has rights to even apply for the bail. But when it comes to a criminal case, then at that point of time it is a discretion of the bail granting authority. They can grant the bail also, and if it's a heinous crime or something, and if they doesn't feel like, then they can even deny the bail. So talking about the historical development and the history of the bail. So bail can be traced back as early as in, I guess, 399 BC, when Plato first tried to create a bond to free Socrates. Now what happened is that in the medieval times, the circuit courts in the Britain was created in the system of bail. The concept of the modern bail chiefly originated from all the medieval laws governing it at the time of the medieval times. So Kautilya's Arthashastra, which is a very famous thing, also mentioned that avoiding pre-trial detention was ideal. Therefore, the concept of bail was somehow prevalent in ancient India too. It is an ancient thing. Now, during the 17th century, that was the Mughal period, so bail was practiced, but it was practiced in the other forms, which was saying zamanat. Now, in today's times, we call zamanat in Hindi and we refer bail. So, currently, bail is governed by the CR 1973 CRPC Act, and bail is not explicitly defined in the act, but the terms which are bailable offence and non-bailable offence, they are defined under section 2 subclause A and of CRPC Act, obviously, and section 436 to section 450 governs the provisions which are relating to the bail under the act. So bail is not, as a section, it is not defined anywhere, but on the terms of bailable offence and non-bailable offence, we can form a definition or form an interpretation towards the bail. Now talking about what are the types of bail present in India. So there are three types of bails present in India: the regular bail, interim bail, and the third one is anticipatory bail. Now this anticipatory bail is the most tragic one here. So starting with the regular bail, so what happens in a regular bail, we all can guess by this time. So when a person commits a cognizable non-bailable offence, now the word non-bailable is really important here. So non-bailable offences are offences which are not that grave, not that heinous, and a police officer can arrest the accused without a warrant or start the investigation without the permission of the court. Those offences are called non-bailable offences. Now the police can take him under custody, and after the custody period expires, he must be sent to the jail. Now according to section 437 and 439 of CRPC, they gives the accused the right to be released from such custody. So this part of getting released of the custody is commonly known as bail. Now a regular bail is basically the release of an accused from the custody to ensure his presence at the trial. Bail has this simple meaning only. Talking about interim bail. Now this seems a bit complicated, but it's not that, it's very easy. So starting that this bail is granted as a temporary means and granted for a short period of time only, either during the time of pendency of an application or when the application of anticipatory bail or regular bail is pending before the court. Now interim bail is always conditional. Remember, the conditional word here is always mandatory, and interim bail is always conditional, and it can be extended or it cannot be extended. That depends totally upon the court. So, but if it expires before the accused has been granted an anticipatory bail or regular bail, and he fails to pay the amount which was required to continue the bail, then he loses his rights of freedom and can be taken again into the custody. If one doesn't pay the amount, he can be taken back to the custody. Now coming to the most interesting one, which is the anticipatory bail. So anticipatory bail is self-defining, and for the people who doesn't know the meaning of anticipatory bail, so it is a type of bail which is given to someone who is in anticipation of getting arrested. If one has a feeling that yes, he might have something wrong, he might have done something which is a non-bailable offense by the police, then he can demand anticipatory bail. But it's not that easy. For getting and for granting anticipatory bail, there are many conditions, discussing a few about. So this is a very essential bail in recent times, and because business rivals and other influential people in today's world often try to frame their opponents in the false case, and this is an advanced bail mentioned under section 438 of the CRPC, and a person who's being granted the anticipatory bail, that person cannot be arrested by the police. So it's obviously a good provision that if you feel that someone can make you fall or make you trap under a false case, you can anytime apply for the anticipatory bail and get yourself freed from the charges. So, thank you.